Namaskar viewers. In this lesson, we shall try to understand the latest developments in the laws relating to companies, investment, securities, insolvency and bankruptcy. The life and times of any nation do not remain static. The same is true about the laws. They require to be changed and updated to suit the needs of the changing societal conditions, economic landscape, contemporary global developments and the new policies. This is more so in the case of corporate laws. During the course of presenting number of lessons on the three important areas covered by this Swayam course, a few latest developments could not be incorporated. This lesson makes an attempt to give a summary of the updates in the selected areas of corporate laws in India till August 2022. First, let us have a look at the changes made to the Companies Act 2013. In light of a fast growing economy and the resultant dynamism in today's business environment, India has witnessed a significant positive shift in the corporate governance and regulatory framework over the last many years. The enactment of the Companies Act 2013, which replaced the Act of 1956, aimed to bring Indian company law in tune with global standards through significant changes relating to accountability, investor protection and disclosures. The Companies Act 2013 and its subsequent amendments intend to promote accountability and transparency and ease companies' compliance burden. These changes are the result of the recommendations made by various committees in recent times. The Companies Act 2013 has undergone significant amendments by way of the Amendment Acts in 2015, 2017, 2019 and 2020. The Securities and Exchange Board of India Act 1992, the Securities Contracts Regulation Act 1956 and the Depositories Act 1996 were also amended by way of the Securities Laws Amendment Act 2014. It is pertinent to note that the Finance Acts have also made some minor amendments to these acts. Under the Companies Amendment Act 2015, certain major changes have been introduced. They include removal of requirement of minimum paid up share capital. Now, the private company and public company are not required to have a minimum paid up share capital of 1 lakh rupees and 5 lakh rupees respectively. This Amendment Act omits such requirement. Dispensing with mandatory common seal. Section 9 of the Act made it mandatory for every company to have a common seal, but the Amendment Act dispenses with this mandatory requirement. Removal of declaration of commencement of business. The Amendment Act has omitted Section 11 of the Act, which required a verified declaration with the Registrar of Companies that each subscriber had paid the requisite value of the shares agreed to be paid and that the minimum paid up share capital requirement had been satisfied. Punishment for acceptance of deposits introduced. Section 73 of the Act prohibits a company from inviting, accepting or renewing deposits from the public except in the manner provided under Chapter 5 of the Act. Under Section 76A, new penalty provision is introduced. Public inspection of certain board resolutions prohibited. The amendment to Section 117 clarifies that no person shall have the right to inspect or obtain copies of resolutions passed by the board of a company relating to matters like buyback, issuance of securities, borrowing or investing monies, approving financial statements, granting loans, acquisition of control, etc., prescribed under section 179 clause 3. Losses to be written off before declaration of dividend. Rule 3 clause 3 of the Companies Declaration and Payment of Dividend Rules 2014 provides that in the event of inadequacy or absence of profits in any year, a company may declare dividend out of its free services. The Amendment Act has added this as a proviso to section 123 of the Act. Regulation of transfers of unclaimed dividend and shares. Under section 124 clause 6, the Amendment Act has clarified that if dividend has not been paid or claimed for a period of 7 consecutive years from the date of such transfer, then such amount shall be transferred by the company to the Investor Education and Protection Fund along with the shares in respect to which the unclaimed or unpaid dividend has been transferred. Winding up cases to be heard by 2-member bench. The Amendment Act provides that the winding up cases are to be heard by 2-member bench instead of a 3-member bench. Offences triable by special courts. Section 435 of the Act has been amended to include that special courts shall try only those offences carrying imprisonment of 2 years or more. This amendment now allows the magistrate courts to try minor violations. Now coming to the Companies Amendment Act 2017, it introduced enlarged definitions of associate, holding and subsidiary companies, issuance of shares at discount to creditors, removal of restriction on issue of sweat equity shares. There are changes impacting listed companies which include limiting the liability of directors for misstatement in prospectus and relaxation in filing of returns apart from doing away with the requirement to file a return with the registrar of companies with respect to change in the number of shares held by promoters and top 10 shareholders of such company within 15 days of such change. As to the directors and key managerial personnel, the changes include expansion of the definition of key managerial personnel by giving the board of directors the power to designate an officer of the company who directly reports to a director in old time employment of company as a KMP. Modification of residency requirement for resident director, permission to independent directors to have limited pecuniary relationships with the company without compromising his independence, exclusion of directorship in dormant companies in determining the limit of 20 companies, and removal of provision relating to insider trading under the Act in the light of the comprehensive insider trading regulations made under the SEBI Prevention of Insider Trading Regulations 2015 applicable to the listed entities. Now coming to the Companies Act 2019, the major changes which have been introduced are broadly aimed to improve the existing prosecution system by imposition of stricter penalties under various sections on the companies as well as the officers in default, recategorize certain compoundable offences as civil defaults and to remove the criminal liability attached to them, transfer some of the approval powers from NCLT to the central government, that is the registrar of companies, to reduce the burden of tribunals, bring accountability to the corporate social responsibility activities undertaken by the companies, not only in letter but in spirit too, and bring greater accountability with respect to filing of documents. The Companies Amendment Act 2020 made certain key changes in the company law, which include decriminalization of minor offences, definition of listed companies by excluding certain companies, empowering the central government to allow certain public companies to list their securities in foreign jurisdiction, reducing the time period for providing offer letter to the existing shareholder under rights issue process to less than 50 days, declaration in respect of beneficial interest, periodical financial results. Then with regard to corporate social responsibility, section 135 of the Act has been amended to provide that if the company has spent excess amount in any financial year beyond the 2% statutorily mandated corporate social responsibility contribution, then such company can adjust the amount of CSR spent in subsequent years to set off the excess amount spent. Further, contravention of these provisions would result in penalties. The amendment has also prescribed that there would be no requirement of CSR committee where the amount is less than rupees 50 lakhs. Independent directors and non-executive directors, in their context, section 149 and 197 of the Act have been amended to bring the independent directors and non-executive directors under the remuneration payable as per Schedule 5 in case of no profits or inadequate profits. Constitution of NCLAT benches. Section 418A has been inserted with the objective of setting up more benches of National Company Law Appellate Tribunal that will ordinarily sit in New Delhi. The said benches of NCLAT will be constituted by at least one judicial member and one technical member. Withholding of property of company by employee. Section 452 has been amended to provide that the imprisonment of such officer or employee for wrongful possession or withholding of property shall not be ordered if the court is satisfied that the company has not paid to that officer or employee his dues towards provident fund, pension fund, gratuity fund or any other fund established for the welfare of officers or employees maintained by the company, or any compensation under the Employees Compensation Act 1923 in respect of death or disablement. Producer companies. The new chapter 21A provides regulations with respect to incorporation, registration, formation, voting rights of members, general meetings, share capital and mergers and amalgamations of producer companies. The Amendment Act of 2020 has the potential to promote foreign investment by facilitating the ease of doing business. The decriminalization of certain offences would help safeguarding investors against criminal liability for minor non-compliances, resulting in increase of foreign investment. Various measures such as the constitution of appellate tribunal would provide swifter redressal of grievances in India. The introduction of producer companies would also be beneficial for agriculture, handlooms, handicrafts and other related industries. The Amendment Act of 2020 thus is expected to ensure greater accountability and strengthening of corporate governance norms and compliances in the corporate sector. Now coming to the amendments of securities laws, in order to provide for an alternative and efficient dispute resolution mechanism for securities laws violations, the Securities and Exchange Board of India (SEBI) introduced the consent mechanism through a letter in 2007, partially modified in 2012 and subsequently codified through the SEBI Settlement of Administrative and Civil Proceedings Regulations 2014, pursuant to the notification of the Securities Laws Amendment Act 2014. This amended law expressly empowered SEBI to settle matters with a view to removing any ambiguity over the validity of the settlement process. This regime specifically excluded certain serious violations, example insider trading or fraud, from the purview of the settlement mechanism. The Securities Laws Amendment Act 2014, the objective of which is to give more powers to SEBI to curb fraud and to protect the investors in the securities market. It amends the SEBI Act 1992, the Securities Contracts Regulation Act 1956 and the Depositories Act 1996. Taking from the learnings of the growth and development of the securities markets both in India as well as offshore, and in order to iron out the issues observed with the implementation of the 2014 regulations, SEBI constituted a high-level committee on December 14, 2017 under the chairmanship of Justice A.R. Dave to review the settlement mechanism and to suggest necessary modifications. Based on the recommendations of the committee and the feedback received from the stakeholders, SEBI notified the SEBI Settlement Proceedings Regulations 2018. The regulations made the regime principle based, giving more flexibility to SEBI to settle certain serious offences except in cases having market wide impact, causing loss to a large set of investors or affecting market integrity. Based on its experience in the implementation of the 2018 regulations, keeping in mind the dynamic nature of the Indian securities market, and to streamline and further harmonize the 2018 regulations, SEBI initiated a consultative process in September 2021 in respect of its proposed amendments, most of which were approved in the board meeting held on December 28, 2021 and subsequently notified on January 14, 2022. Now coming to the privatization and foreign investments in India. As India is an emerging economy with a large working population, the central government has been trying to tap into global investments and push India towards becoming the most favored manufacturing hub across the globe. The Make in India and Atmanirbhar Bharat schemes promulgated by the central government act in tandem with the liberalized foreign direct investment regulations in India and have provided a much needed impetus to economic growth. Additionally, the central government is also exploring disinvestments in public sector undertakings to attract potential foreign investors to reduce its fiscal deficit, allowing non-resident Indians to invest up to 100% in India's flagship air carrier Air India, thus paving the way for Air India's privatization, giving its in principle approval for strategic investment of IDBI Bank. Efforts are on for permitting 100% foreign investment under the automatic route in oil and gas public sector undertakings that have received an in principle approval for strategic disinvestment, thereby facilitating privatization of one of India's largest public sector refineries, Bharat Petroleum Corporation Limited. As regards the March of Insolvency and Bankruptcy Code 2016, since the enactment of the IBC Code, it is continuously changing and amendments were made many times to add key changes to ease the resolution process. Swiss Ribbons Private Limited versus Union of India dealt with the constitutional validity of the various existing provisions in the Insolvency and Bankruptcy Code 2016. The Supreme Court in this case held the IBC Code to be constitutionally valid in its entirety. The court takes into consideration various economic factors of the country in order to determine its validity in the present case. The latest amendment has been made in 2020. This is the fourth amendment being made to the Insolvency and Bankruptcy Code 2016. Justice Rohinton Nariman said in this case, the defaulter's paradise is lost. In its place, the economy's rightful position has been regained, while passing the judgment in favor of the Insolvency and Bankruptcy Code 2016. The decision by the Apex Court in Swiss Rubbers versus Union of India paved way for a proper and recognized method for dealing with insolvents and finding the most economical method for helping creditors gain value from non-performing assets after a lot of crucial experiments to improve economy of the country. Dear learners, we have made a sincere attempt to summarize the latest amendments which emerged in the three laws offered in this course. By way of abundant precaution, it is stated that the list of changes is only illustrative but not exhaustive in nature. The learners are advised to check for further amendments and also for the details of the changes discussed here before from authentic sources. Another sincere advice to the learners is to register themselves for the examination after completing the course, as the pass in this examination would give 4 credits which are also transferable. I hope that you have enjoyed hearing the experts speaking to you on these important corporate laws and learnt a lot of new things. I thank all of you and wish you all the very best in your future endeavors. Sarve jana sukhino bhavantu. Namaskar.